Hello, and welcome to Pursuing Justice, a conversation with Judge Patrick Higginbotham and Professor Michael Tigar. I'm T.L. Cubbage, president of the Center for American and International Law. The Center, or CALE, was founded in 1947 by Robert Story, shortly after he returned from being a senior American prosecutor of Nazi war criminals at Nuremberg. This year, we are marking the 75th anniversary of CALE's founding with programs like this one, which highlight the center's mission, which is to promote the administration of justice and the rule of law, and also to celebrate CALE's history and to preview our bright future. As I'll explain in a moment, our two guests today are important figures in CALE's history. Judge Patrick Higginbotham is a circuit judge of the United States Court of Appeals for the Fifth Circuit and previously served as a member of the United States District Court for the Northern District of Texas, having been appointed and confirmed in 1975. In 46 years on the federal bench, there are few issues of civil or criminal law that Judge Higginbotham has not had the opportunity to observe. And even before he began his judicial career, he had an esteemed practice of law, first as a lawyer in the Air Force JAG Corps, and then as a very successful litigator in Dallas, Texas. And furthermore, Judge Higginbotham has served important roles in the judiciary, such as chairing the Civil Rules Advisory Committee, and in other organizations, such as being a national leader in the American Inns of Court organization. Professor Tigar has taught at American University, Duke University, and the University of Texas, and has taught generations, including my wife when she was at UT Law. But he is especially known around the world for his storied career as a litigator, primarily in matters involving justice and human rights. Just last year, Professor Tigar published his memoir, Sensing Injustice, to great acclaim. And before we go further, I will just use some words written by the judge in 1993 in nominating Professor Tigar for a Thurgood Marshall Award from the ABA. In 1993, Judge Higginbotham wrote, "With every generation, there are a handful of lawyers whose raw intelligence, courage, and instinctive embrace of the underdog hurl them to the front of the never-ending defense of individual freedom. These unique persons have more than their share of nerve, gall, compassion, swagger, and general panache." Well, I think that's a great description of what the professor brings to the table. Now, let me tie these two great lawyers to a landmark in CALE's history. 20 years ago this month, in January 2002, Judge Higginbotham and Professor Tigar motivated and organized CALE's inaugural program to train lawyers to handle the special challenges of death penalty litigation. Professor, I'd like to start our conversation by asking you, what's your recollection of how and why that came about?
Well, Judge Higginbotham had written a number of opinions about the miserable quality of appointed counsel, including his observation in the Macias case that the justice system paid this lawyer $11 an hour and they got their money's worth. It was clear that there was a problem out there. Funding had declined for the federal capital defense centers, and we needed to do something about it. And we needed to not to do something about the policy of the death penalty, but to understand that the law is never what it says, but what it does. And that the just rule of law is a law about the fair application of rules. So we borrowed from the National Institute for Trial Advocacy, where the judge and I had taught several times over the years, and hooked those techniques into real teaching sessions to prepare lawyers to meet these challenges. And it was an exciting time. And I think we changed a lot of lives, and we certainly affected the system that calls itself justice in some important ways.
Judge, do you want to remark on the establishment of the still ongoing capital litigation programs at CALE?
I'm very proud of CALE for having embraced that idea and run with it. The need was palpable. Lawyers who try the cases know that. It's a little more difficult for judges sitting on distant benches to necessarily dive deeply enough into it and comprehend the weaknesses that are there. But they were there, and they're very real. And so the response came to try to train these lawyers. And my immediate thought was that I need Mike, because first off, he also has the teacher's touch, and he had a sense of how to develop this and how best to present this material in a form that these lawyers would embrace themselves. And of course, he is a master at that, and he came in and he did it. We had trained, I think, over 600 lawyers. Now, most of these lawyers do not come from big law, almost none.
Mm-hmm.
They practice out of shopping centers, et cetera. They do not have the resources to dig as deeply as one should be able to. So part of this mission was to teach them how to access various resources, to teach them that the capital punishment is an inevitable binary function, that you have two trials, and that the power of the mitigation case is so critical in so many of these cases, and it's neglected, for example. And Mike then preached those sermons to them, but more than not just a lecture format. One of the things that struck me was that Mike would take a lawyer who had a pending case and take him off into what he called a locker room. And he'd say, okay, now I'm your co-counsel, so it's privileged. Give me your first 10 minutes of your opening statement, your closing statement, whatever. And then as they got into the case, Mike would say, what about this? And what about that? Have you got these papers? This is where you can get these papers. Have you considered that? Yeah, I would go this, then do this, and et cetera, et cetera. And so the lawyers, of course, that's invaluable right on the money in a case itself. As close as we get Tigar to a second year, almost first year, handed these people. And then they developed a set of materials which were not abstract discussions of the law, but very practical, usable, immediately usable motions that needed to be filed. They had a collection of those that we routinely would expect them to have access to. And then the ability to communicate with one another. We were all in this together, pick up the phone and talk to a colleague, seek assistance, et cetera, et cetera. So they left there after weeks of this. It was a multiple week program. It's different weeks, of course, but an all-day sessions. And finally, they graduated. And what I saw at these graduations were lawyers who really deeply appreciated that. More than one said to me that, Judge, Mike makes me feel like the lawyer I always wanted to be, and I'm doing what I thought I would be able to do, and et cetera. And many of those, more than one of them, took their certificates and had tears in their eyes because it enabled them to do what they had a call for. So that's the story. Tigar did it. You get the ideas and throw them out there, and but he has the gift of being able to walk into the courtroom as a powerful advocate and to stand before a class and to teach them as well. So that is an uncommon skill. So the center, I know, is deeply thankful and appreciative of that work, but he is very much the the motivating force and the energy that, the talent that was brought to bear there. And I hope we continue to work that area because there's an ongoing need for that. And I read these transcripts and you can't see what happened and reading briefs sometimes, but you hand me the transcript and let me see what the judge said and didn't say and what the lawyer said, et cetera, et cetera. You get a sense of that. And as long as we have judges who have been there, done that, at least a few of them, we're on the right course. But capital punishment has its own set of substantive and problems, basic problems, morality in my book. But that said, that's the system, and we're trying to make the best of it as we can.
Well, one of the remarks you made there, I'd like to point out, I think most people in this audience are likely to know that in Michael's case, he's not just familiar with the theory, but with the practice. And in particular, perhaps most famously, Professor, you represented Terry Nichols in his trial for capital murder after the notorious bombing of the Murrah building in Oklahoma City. And one of the points that was just mentioned is the fact that in a capital murder case in the United States, there's a bifurcated proceeding, a guilt versus innocence phase, and then a punishment phase. It seems to be a uniquely challenging dynamic to try to challenge the proof of guilt, and then also be prepared in the event that the jury finds guilt to address the question of punishment. Can you talk about how you handled that dynamic?
Well, first thing we tell lawyers is don't wait till the penalty phase before you start trying the penalty case. There are a lot of witnesses about the defendant's involvement in the charged conduct that are not going to be available to you in the penalty phase. That's point one. You got to be ready for that. And we see so many ineffective assistance cases coming up in which the lawyers haven't really thought that far ahead. Now, in the Nichols case, you stand corrected. He was charged with conspiracy. He was acquitted of most of the substantive charges, but so we even wondered we had a penalty phase at all, but that's what Judge Mage wanted to do. And all you civil lawyers out there, it's not all that much different from a bifurcated trial in which you've got liability and damages, or damages and then punitive damages. You got to stand up in front of the jury, and them having delivered you this verdict, and say, look, we accept your verdict. We accept all verdicts fairly arrived at. Yours is. But let me tell you something. Don't let the government tell you, don't let the prosecutors tell you what your verdict means. That's number one. And number two is, we have to take an oath to do what we do here. You took one, I took one. And the oath we took is that if we ever got to this phase, you would apply all of the law, all of the principles that the judge is going to tell you about in considering mitigation evidence. And that brings us back to the power of what Judge Higginbotham was saying. That is, we're talking about whether this defendant deserves to be killed at the hands of the state. And the mitigation evidence that diligent search can present can be of vital importance. I give you one example from the first case we did. My daughter, Catherine McQueen, who's a physician, testifies as a mitigation witness in capital cases. In an astounding number of cases, they get life verdicts. She talked to lawyers about how you do that in great detail so that they could capture it. And it's true. Lawyers hadn't thought about it. As one fellow said at the beginning, well, you're telling us things. That's not the way we do it in Collin County. I said, well, you get a lot of death verdicts in Collin County? He said, well, yeah, we do. I said, well, it's good you're here then, isn't it? Can I just add one thing? You are the center you've got international law in there. The interesting thing is that that capital punishment has become a matter of international law, and it's under active consideration by the Inter-American Commission on Human Rights. In fact, they've issued decisions about that. So this has become a field of study that goes beyond what we might have thought it was 20, 30 years ago.
Judge, one of the things I mentioned, and I think that comes through in your observations about the importance of the transcript, is that you came to the bench with a great deal of courtroom experience as an advocate yourself. And that's partly as a result of your, at a very young age, being in the courtroom so often as a military lawyer. How did that experience shape your role and your approach to being a judge on the bench?
Well, I always thought that trials was what lawyers did. I didn't know much about office work and that kind of thing. My image as a lad growing up, and influenced, I'm sure, by my mom and her father, that that's what lawyers did. And so then it happened that as I came out of law school, I had several options that didn't work out but what did happen there was that I was offered an immediate appointment to the Air Force. They were after me to become a judge advocate, and I thought that I wanted to do that. I wanted to serve my country, and so I signed that on to that, and I didn't really fully appreciate that there was any difference. That's what I started doing. I tried 5, not big trials, 3 or 4 day trials within about 3 months of getting there. So, and that's all I did for 3 years. Then when I came out, I went to a firm and I thought I was going to be so far behind, but it turned out I wasn't. I had really examined more witnesses, cross-examined more witnesses, and tried more cases than a number of the people, quote, trial partners, had in recent years in any event. And so it all worked out in that fashion. But it is in the trial of these cases that the justice is ultimately served. And Mike, one of his great victories is going into a general court martial, and one that jumps out at me as a signal, and he talked about it in his book, but I accented it because here's Michael Tigar, who the general reaction to is going to be, this is an outside agitator coming here and telling us what to do, as they say down the deep South. And to go into the courtroom, which has its own sense of propriety and rules and so forth in the tradition. And I have a kind of confidence in the structure of actually the way it works day to day. But here he came in to that setting to defend she was a female officer, a major, as I recall. And in the event that he achieved a not guilty. And that is difficult to do in the military system, not because of the rigidity of their outlook so much as it is the care with which the OSI, the FBI, and the others prepare those cases. They just don't like to go to trial unless they have a lay down hand. And so they're very careful about that. They also have a grand jury quote, but it's Article 24 inquiry where an officer conducts an investigation while you're representing a client. And so you sit and effectively sit on the grand jury, and you can win a lot of cases there. So the system is a good system. But I thought that in many ways that demonstrated Mike's versatility. But the versatility stems from the ability to discern what's happening around you and how best to present the client's interest.
Well, I appreciate the encomium, but a general court martial, of course, all the members of the court outrank the defendant. We are talking about military officers. Now, in a civilian jury case, we're talking about jurors drawn from various parts of the community. And in both sets of cases, you are talking to identifiable human beings. That's the reason for all you judges that we need voir dire, so that we can figure out to whom we're going to be speaking. But one of the themes of the defense there was that, all right, there were ill-motivated civilians that made charges against the major that I was representing. Gee, is there a parallel for that? How about Cicero, Marcus Tullius Cicero, defending General Murena against allegations made by ill-motivated civilians and talking to that jury about the nobility of military service versus these ill-motivated civilians. So the summation kind of wrote itself as you translate it into something that might reflect the views and experiences of the people that were going to decide.
Professor, what are
that's your CLE for the day.
Well, that's what jumped out at me was that when you actually look at how the case was tried, that I nearly fell out my chair laughing when I saw what Mike had done, because it was brilliant. It would never occur to me to do that, but all of that, part of that comes from the need for broad-based education. Somebody reads a lot and is familiar with a lot of history and et cetera, et cetera. That helps. Knowing life's experiences, and that translates the ability to talk to people and to know how to persuade. And you can multiply your life's experiences by doing a lot of reading. That helps, in addition to just living it yourself.
But it goes for judges too. One of Judge Higginbotham's best articles is called "So Why Do They Call Them Trial Judges?" in which he arraigned his colleagues on the federal bench for not getting into court and mixing it up with the lawyers. Instead of receiving the papers in the chambers, turning them over to the clerks, and then, shoving results out underneath the door where the lawyers can get at them. But I don't know, Judge, my perception is that beginning as a federal district judge, your willingness to get on the bench and to talk to the lawyers, talk things through, was a basis for making informed decisions. And then that led up to the point where Judge Higginbotham trusted the jurors then, if the case went to trial, to get it right.
Well, I came to the bench with a great confidence in juries. When I was in private practice, I defended some of the Fortune 500 companies of antitrust violations. And I've sat in boardrooms and said, I want a jury, we're going to try this to a jury. And then the reaction is, what?
Yeah, what? Yeah.
Well, people off the street, this is a complicated business. Yes, I said, the nice thing, this is what you want. Ultimately, what we were going to be trying to persuade the jury of is that the difference between injury to competitors and injury to competition. Injury to competitors is what we want. It's injury to competition we have to protect. Point one. Point two is that we have to protect the system in order to make it work. If you leave it alone, it will destroy itself. And we know that. That's why Sherman Act came on. Very soon after this country really got going industrially. The recognition of that basic phenomenon. Jurors understand that. But with a judge, you've got a lot of barriers already up in front of you. And the problem with that is that you don't know what all they are. I start making an argument and these doors start closing and I don't know what they are. And I had a case like that. I know something about that. I've heard about that. I know about that. And so that there is a difference. But apart from, not in the matter just of trial tactics and cultivating success, and so all those are worthwhile. But behind this is the powerful commitment to the answer to who decides, is that it best be left with the people. And that our founders darn sure were fixed on that. Don't forget the powerful reaction that came back when they sent that Constitution out for ratification. And they came back to, whoa. Where's our juries? Where's our juries? You're not going to mess with our juries. We got a lot of other issues on this thing, but that one, that's a starter. And Madison saw that, and and they quickly stated it with the explanation. No small part is, oh, well, it's a given. It's no, of course, but we'll see it, and they did, and that is a very powerful commitment. For the originalists out there that want to do and try to adhere to the teachings of the fathers in that constitutional structure, you can't escape that incredible commitment to jury citizen participation. But yet we see a love affair with arbitration by the courts. It comes from the courts. And with ADR, all those have their place. But one thing that is just so basic. I reminded sometimes of the reality is one travels around Texas or any other state, and you go out into the rural counties and so forth. What's the center of that town? It's where? What's there? What's there is a courthouse. And that's the center of the activity in so many ways. The deeds records are there, the marriage records are there, so on and so forth. And that's where the trials are held. And that is a powerful lesson. And then our commitment, it all bound up with these general statements about rule of law and so forth. But citizen participation is so enormously important. It's right there with voting.
Judge, you underscored the importance in the civil society of the juries. People who practice in the criminal courts, of course, realize that more and more a criminal trial becomes a rare thing, and the vast majority of criminal charges are being resolved by plea bargaining. Do either one of you want to comment on what you see about the trends and either the positive benefits or your concerns with the nature of that system?
Well, the 97% of federal cases are now being resolved in plea bargains. I've arraigned and criticized at some length the unreality of the idea that these are true bargains. Federal defender services and state defender services are underfunded. The law of ineffective assistance is not as vigorous as it ought to be. And under those circumstances, we have a world in which a lot of people are pleading guilty simply to avoid the draconian punishment that is that is promised to them if they persist in going to trial. And we can't list all of the ways in which plea bargains aren't true bargains, but I think all of us ought to be concerned about the fact that the United States incarcerates 5 to 7 times as many people as a percentage of population as any comparable country. And those folks are being shuffled into that system by these so-called bargains. And disproportionately, these are marginalized people, poor people, people of color that are subjected to this. You cannot maintain a civil society that is worthy of the name unless something's done about this.
It is of course, Mike and I are on the same page on that for sure. Fortunately, some attention is being, some very informed attention has been going to that. And I would give a shout out to my former law clerks, Stephanos Bibas, a very bright young man, very able and a passionate individual and strong lead. Bears the label conservative, but to go to the content of that, what that means. And he spent a year with me and a year with the Supreme Court, and then instead of going immediately to the big law firms and so cashing in, he went to the Southern District of New York to try cases. Mm-hmm. I always said, no matter what you end up doing, if you have some of that experience, it'll serve you well. Well, he turned his scholarly eye to what was going on in plea bargaining, and he has made a substantial contribution in his writings as he joined the law faculty to this area of research. exposing the difficulties that attend the plea bargaining system itself. So there is that little flame out there, and hopefully it'll find some tinder and go on. We should look hard at those deals that are being struck. It begins also with a high court, and the basic laws that we impose. The difficult problems of translating. You look at the civil side where you wouldn't think of putting money at risk without fair discovery, et cetera, and then you put life on the line, and it's no, that's unheard of. We don't want to do that kind of thing over here. And we have the Brady principle, which most lawyers are familiar with. Certainly, the criminal bar is part of their bread and butter, which imposes the obligation, decision by the Supreme Court, a constitutional obligation to disclose exculpatory information that at trial, well, the figures that I gave you, 97% of them, that's not at trial. And so what should happen, of course, is that all the cards are on the table, and then the negotiations can go forward and so forth. But so long as you leave that uncertainty there, you don't necessarily have the defendant aware of what's there and what's not there. Most importantly, so ultimately what we're saying is this is an issue. It is a phenomenon, and it didn't happen without some powerful causal forces. But it, in some ways, parallels the same diminishing trials. It's sort of a reaction that's simpler, more efficient, business-like way of doing this dirty work of trials of people and civil suits, disputes, et cetera.
I'd like to add to that, Judge. I want to shout out to the late Irving Goldberg, because you mentioned that the prosecutors don't feel obliged to disclose exculpatory evidence during the bargain negotiation. And yet it was Irving Goldberg who said that plea bargaining is like a dance, and you're not supposed to dance your partner towards a hole in the dance floor. And if that were translated into law, then the idea that you'd have to make disclosure of exculpatory evidence could live again. And so I commend that to the members of the Fifth Circuit who may want to look back at Judge Goldberg's wisdom.
Well, thank you. Reminded me of a dear friend and a colleague, much senior to me. He was a powerful force and a gentle soul in so many ways. In Dallas, he was a Dallas lawyer, and then went to Beck, et cetera. He was I won't pause to give him all the accompaniments he deserves, but he was a wonderful colleague. And those years, I got to know him in more recent years, but as a young lawyer, I had a little business matter dispute with my client, and he had a client, and as was the custom, the young lawyer would go then to the office of the other lawyer. They sit down and try to work it out. And I guess the President Barr wouldn't understand this, and so I did. I took my file and went over, and he's a senior partner of a major law firm, and I sat down. He treated me like I was a highly experienced lawyer rather than the pup that I was, and gave me full credibility. And we chatted about it. And we solved our problems and so forth. And I came away at that time. My first impression was one of gratitude that he treated me like a lawyer, and I respected that, and that carried through. So it's important that we pause as we have these discussions to note some of the really outstanding persons that have walked away from the private world and either private opportunities, I should say, to take on causes on the bench, off the bench, whatever. You can make a lot more money trying civil cases and and defending capital cases. Let's put it that way.
Yes. Well, Irving Goldberg is also in the law of equity, the contributor of in a case involving Kentucky Fried Chicken. He began his opinion by saying the issue in this case is whether the man whose chicken is finger licking good has come to court with dirty hands.
Well, he loved it. He had a great sense of humor, and he really thought that we ought to bring some life to these opinions. They shouldn't be wholly dry. And so he carried on in that spirit. We've had some my circuit, and going back before when I came to district court before the 11th Circuit across the South, was a distinguished circuit. I had great respect for it. I still do. But as a young lawyer, I had the privilege of arguing before them in some matters of significance, but I went there with that great appreciation for it. As I raised that question about to some of my colleagues, I said, well, with our courthouse, so one of the problems I hate about not being able to get into the courtroom is that as a lawyer, when I walked into the East courtroom, West courtroom, the en banc courtroom, it's like going to church. I had a sense of that, that this is sacred ground, and we're here to do this is a higher calling kind of thing. This is not a street. You had that sense of it, and the question was, when we try to conduct business outside that, did we lose something? And I don't know the answer to that, but it is simply to point up the reality that tradition and the long term in certain traditions are important, primarily the personal kind, I think.
But
that's where we
Judge, I'm sorry. You mentioned that it was talked about the founding of CALE, and of course the founder had come back from Nuremberg. And when you talk about the place where things happen, I think about the trial chamber in Nuremberg as a place where these principles of international law about human rights and humanitarian law could become knowable, justiciable, and non-derogable. That is to say, these fundamental ideas about justice, which I think Stalin would have just rounded up the German leaders and shot them all. Churchill probably was willing to do so also. But the notion you were going to have a trial which would put beyond the reach of all but the most captious critic the reality of what the Holocaust and what the Nazis had done. The idea that you're going to conduct that trial in accordance with rules, and you're going to announce to the world that from here on out, human rights violators better look out, because there is a principle of accountability. I don't want to, get all dramatic about this, but the idea that an institution that is founded upon and seeks to advance that principle is pretty impressive, especially in today's world.
I would just simply echo that. If you think back on it, at that moment in time when Justice Jackson was considering accepting that job, that task, Europe was decimated. Unlike we were very, very conscious of the fact that following the first foray in WW1, that the League of Nations was defeated in the Senate, and we walked away. And this time, the sense was when General Marshall and those powerful figures, that Dean Acheson, et cetera, that Europe itself is there, and we want to seed a democratic government. We want the seeds of democracy to be planted, and have best to do that? What a great way of doing that than to demonstrate the rule of law. Now that, having said that, this was not without some risk. And for Justice Jackson personally, his career, his legacy, as he would see it, etc. But he had been a very strong trial lawyer, powerful trial lawyer before he went to the bench. And so he had those skills. But one of the criticisms that was thrown in his face as he got there said, you advocate the rule of law. There is no law of war. And of course, one of the German principals was one of the most articulate defenders of a fascist system, and very smart, clever man. And it was the cross-examination of his that man that was so one of the critical points and junctures of that trial. But it's the fact of it. It's simply the fact of it that one, it did say that there is a law of war in this sense, and that is the atrocities, the Holocaust, those things. And he started and opened this trial with a display of the photographs of the bodies, and silence fell in that courtroom. So from the outset, then he was articulating, yes, there are limits, and even to war itself. So I think that Story was there as executive assistant, and then when Jackson came back to the court, he remained, and the trials went on. And there were I don't remember the numbers, but there was more than one acquittal.
Yes.
So it wasn't a sham proceeding. There were distinguished figures on the bench, and they returned, and it was conducted in a way that said to the world, that cynics could call it a sham, whatever you want to call it, but contrast that to what would have happened otherwise, continuing right on. But
I would add that I think that these issues are before us now, and certainly worthy of study, because the Supreme Court has before it this term a case in which someone who was the subject of illegal rendition and torture is seeking judicial review. And the issue is whether the Justice Department's claim that all of this must be behind a shield of state secrets privilege is going to be sustained, or whether the system that calls itself justice can proceed in the way the Supreme Court said in Reynolds, that the judicial control over the evidence in the case cannot be abandoned to the caprice of the executive branch. I think that's 345 U.S. 1, and the case still endures. And I will say this, that the Inter-American Commission on Human Rights held that a federal death penalty case was infected by racism and ineffective assistance, and issued its opinion in the closing days of the former president's administration. And the response of Attorney General Barr was to say that he was ignoring what the commission found, and he ordered the young man executed, despite what the Inter-American Commission had done. So I appreciate Judge Higginbotham and the center for reminding us of this lesson, that this is a battle that must go on in every generation.
Well, I think it is appropriate that on the 75th anniversary of the center, which I've been a part of for so many years, and then Mike as well, that we lift up the aspirations of Story. Story was a signal figure. I mean, think about this young lawyer who ends up on the staff, Justice Jackson in Germany. Then it just happens. It just happens. He comes back to Dallas, and then he just happens. He becomes dean of the law school. It just happens. He becomes president of the American Bar Association. This was a talented young man, and he served well and performed at a very high level and made a significant contribution. And the 75th anniversary is the marker to look back on that and to try to frame it and to put it in the historical context And because it's the old story, if you want to know where you're going in the future, you got to look back to see where you're coming from. If you look back at what your trail behind you, you get a little guidance about where you're headed. And I think that's important that we not forget, that we keep evermost in mind. That's what we're about. In law and in teaching senior officers of major police departments, the protocols, procedures, situational ethics, all sorts of things, and across the board. And bringing in these international students, young lawyers from around the world, as we do in the summer over many years. That's been all these years. We had 40, 50, 60 young lawyers staying there for weeks at a time being introduced to the American system, down to taking them to the baseball game, to listening to law professors describe our system, But they went home. And many of those people have become heads of government, heads of the judicial system, distinguished lawyers in their own systems, et cetera. And those seeds are out there. And that's very important. They're not just blowing in the wind.
You mentioned, both of you, Robert Story, who founded CALE, and as I said, our mission and vision is about bolstering the rule of law. And Robert Story had as succinct, I think, and useful a definition of the rule of law of any I've encountered. He said, the rule of law is the polar opposite of the rule of power. And I think if you're just going to put the rule of law in a few words, that's a pretty good nutshell to use.
I think that not only is that apt, but let me put two glosses on it. First of all, Justice Scalia was fond of saying the rule of law is the law of rules. Well, I think he got that wrong, because the just rule of law is a law about procedures that are transparent and open, that determine whether rules are going to be applied to somebody. That is a longer way of saying that it's about power, how you exercise power. And the second thing is that, and this has happened, and current events, I think, pointed up to us, is that there's so many people now, including people that wear judicial robes, who are anxious to see particular results reached. And they're therefore willing to overthrow our most cherished convictions as to how legitimate results, ought to be reached or must be reached. And we go back to 20 years ago and the capital punishment training and discussion we had. These lawyers were learning how to deconstruct the system by which these life-death decisions are made, to lay it open for examination so that they and the judge and the jurors could participate in it in a meaningful way. And the demonstrable impact on life verdicts shows that that's right. So yes, what Mr. Story said is right. And what he also, the subtext for everybody listening is that, everybody can think about what they can do about injustice today.
Well, yeah, one of the things you look around, that's Europe today, and domestically as well, you see the powerful tendencies of the forces that seem to be built into the psyche of our people operating, the tendencies to move from a free society to a fascist society. So one of my dear friends from high school days, who year ahead of me in high school, my campaign manager when I ran for student body office, and later my 5 years we worked closely together in litigation at the law firm Cubbage in Burlington in Washington. Harvey Applebaum, brilliant student. He went directly from my high school in Alabama to Yale, and junior 5/8 there in the top. It's about 3 or 4 of his class at Harvard Law School, and a great working for Dean Atchison then later at Covington. Wonderful man, wonderful man. His daughter Anne, I was watching her on television and reading her book. and there are stories of a move of the tendencies of democratic societies to move into authoritarian societies. I would challenge people to read Anne Applebaum. She's thoughtful, I feel, and one of our most brilliant commentators. She married a Polish figure at the head of the Polish government and wrote about the transitions there. But today she is also one of the great minds in international affairs, and with a keen eye toward triggers and the various tripwires that are there for governments who would hold themselves out as democratic, and that these are ever-present forces and now almost natural forces that push against it. And so I come back to Mike's point that we need people vigilant against it, and lawyers are awfully important to that. I always say that the lawyers are the oil that make the Madison's factions theory work. Lawyers ultimately are going to be the ones that resolve these problems or play a role in guiding people to do that. And a final comment about that is that I remind people that the lawyers are joined at the hip in one way. They're lawyers, but they play roles. Some of them are prosecutors, some of them are defense counsel, some of them are judges, but they're still lawyers. Those 9 justices are lawyers, and they're all the strengths and the weaknesses that lawyers have. But they're lawyers, and they're devoted. They join together by that commitment to a rule of law, and that rule of law is not empty. It shouldn't be, and that's what CALE is about, to try to keep that rule of law front and center, and to ensure that it does have content. And it's appropriate that we look back to one of the founders who devoted a good bit of his life to that, at not inconsiderable risk. So and I have to say, it's the Mike Tigars of this world we need. I'm not sure how many we could handle, but they play such a powerful role itself. I think about that. Go back to Oklahoma City. What was it, like 138 people killed?
167 people dead. And
hundreds of millions of dollars, all kinds of beautiful new courthouse devastated, children killed.
Yes,
I can't think of a more heinous crime, and then, but yet, we have a system, and as Mike so always puts his finger on it, that rule of law. It asks the questions about power and the rules that we will turn to bear on that. And I think that great credit to the judges there in that Almora building. And I came away with it greatly impressed when I got a phone call and they asked they were seeking out someone. Said, we know what the stakes are here, and we want this man to have the very best counsel that he can give. And they said to you know a lot of trial lawyers, and they had several names, and I said, well, I'll give you 3 names, and they said, what? Tigar. The lad said, I got the picture. Can you persuade him? I thought, could I talk to a firehouse dog to get off the truck? So I called Mike, and he and I made him call me back the next day and to wait. And no sooner than I'd gotten the words out of my mouth, and he said, which one? And I told him, and he said, I'll never forget this. He said, got to get a severance. I said, wait a minute. Whoa. He was, and I know that it's one of many, but that's one that is out there that the public knows about. And I don't think that a lot of people will fully appreciate the considerable demands upon on Mike as really the leader of the band. He had a good guy with him too. His sidekick was a good man, and so so we want to mention him as well. Mike always does do that appropriately. So, but that.
Well, I want to point out that defense capital case, you get 2 lawyers, and Ron Woods agreed to be co-counsel. And he illustrates what Judge was saying, because Ron had been a prosecutor in Harris County. He'd been United States Attorney for the Southern District of Texas. He had resisted the Thornburg memo and told his lawyers they had to obey the ethical rules. We had then been colleagues in representing Senator Hutchinson. So he brought to the table a set of principles and skills derived from having been on the other side, as it were. And that proved invaluable in terms of making that connection to the jury. But it is amazing. It still is amazing to me to look back and see 167 dead people, sounds and pictures the jurors had already seen going to be played again, understanding that the world has no such joy to give as that which it takes away. And yet, seeking and asking, and I think eventually getting close to a quiet place within which the process of judgment could take place.
Yes, I think that trial is a continuing monument to what to the strength of the rule of law that put a lot of force and pressure upon our processes and procedures. And the response to it was, we want to protect those rights and procedures, even for this type of crime. And the judges sought out what they thought would be the best way of doing that, was to ensure that there were highly competent counsel representing. In other words, that the process would work at its optimal level. And it did. I would have said that regardless of how that case came out, that his client prevailed in that sense. But regardless of that, however that had ultimately gone, looking at the reality of the offense itself, that was a real test and a pressure upon the system, and it passed it. It passed it. And so I look at Oklahoma City as a success story. And I like to lift it up because to remind people of what we are and how the rule of law is resilient. And those who dance away from it are not going to succeed in the long run, I would hope. But ever present, though, is the threat that a democratic society is going to have. That's been the history. And that there are those who do not want that, and we're going to be challenged and challenged. That is a challenge that will never go away. And that's why we have lawyers and people and others, figures who sign on to that. And there are stories of this generation. So and there are young lawyers out there. The American Ends of Court Foundation, that I have a great love for, is really calculated to get lawyers out of their offices together and to talk about problems in a way that they know each other, and to knit the common bond that they have, and to share that in that community of interest, if you will. And there is a hunger for that, and it's still proceeding. Yes. But those things it breaks down the we-they mentality there. With a lawyer, like a young lawyer can pick up his file, walk down the street to the senior lawyer's office, sit down and work out this problem. So we've got on a positive note, we see these great developments, but I salute the CALE, and we're real privileged. We've got a new CEO. We've always had great leadership on our board, and an incredible staff. incredible staff, and that continues. So on a real bright note, I'm very pleased with. I'm very pleased with it, and I know that many others that I work with on that are as well. So always a pleasure to be with Tigar, because he always reminds me of what we're about, because he's a walking monument to the rule of law. We don't always agree.
Yeah.
Maybe a little further left than I am.
Well, yeah, but you're the judge, so you in the end you got the only handle on the jack, you know.
But on the basic is that we're there.
And I think
That's a great note, Judge.
Yes, don't forget to mention Mark Smith. Go ahead. Sorry.
Well,
Mark Smith, despite his Yale education, we teased him about, came down to Texas. It's just been a remarkable figure.
Yeah.
Well, at the top of the hour, and so we told folks that we would use their lunchtime and then excuse them. So, Professor, if you have anything you'd like to say, we mentioned Dean Story and a few parting words that he left us. I think underscore the things we've heard today. One was that the profession of law is not a trade. And I think many of your comments today underscore that. You talked about the courage to defend unpopular causes, and Professor, you certainly demonstrated that courage. And I think the final point that's worth remembering that Dean Story saw is the struggle for the rule of law is endless. As the judge said, the commitment must be renewed in every generation. So, any other parting words?
No, I think that's it. Thank you very much for the opportunity to be part of this, and also for your thanks for the opportunity to work with you in the past. Let's hope it continues.
I would say the same to all of you, and to my dear friend Mike. I continue to salute you, my friend, and to my former law clerk and distinguished lawyer, and now the leader of CALE. I'm very proud because I'm very confident in him. Thank you.
Well, thank you to everyone who's joined us. Again, there's details in the chat for following through for those who want Texas CLE credit. We very much appreciate your interest. And if you'd like to learn more about CALE's history, you can visit the website cailaw75.org. Thank you.